Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 251 of the NCDWI Guy podcast. On today's episode, we are talking about presenting cutting-edge defense. If you have a novel argument in a DWI case, how can you give yourself the best chance of winning that argument? How can you overcome a stigma that I have sometimes heard talked about by DAs of this lawyer being a smoke and mirrors lawyer? And how can you give your client the best chance of getting a dismissal or a not guilty? So we are going to be focusing on ways to get judicial buy-in on a novel issue. Before I dive into today's episode, I want to remind everybody we've got our Attacking Speed in a DWI CLE coming up at Campbell Law School in Raleigh on March 7th. I am pumped about this CLE. It really is going to be amazing. Think what NHTSA is to DWI. This is basically police academy training on speed detection and radar use as applied to the case, knowing how time distance measurement works better than the officer, knowing how to use radar better than the officer. That's what we're fundamentally trying to get down to. I have officially locked in on that Thursday, the day before the CLE, March 6th, a networking event for all of the attendees at the Drive Shack in Raleigh, calling the event Driving with Freedom Fighters. So just a blast of a time. We did a event for our firm a couple of years back at Top Golf in Charlotte and just had a blast. It was so much fun. So Drive Shack in Raleigh, we're going to be doing a networking event from 6:30 to 8:30 p.m. on Thursday night before the CLE. So if you're planning on coming to the CLE, make sure you're at the networking event. I am covering the cost of admission to Drive Shack as well as drinks. So come have a good time with us. It's going to be a blast. So today I'm going to give you 5 ways to win your novel DWI case with a judge. 5 ways to win in front of a judge on a novel DWI issue. Before I dive into those 5 ideas, I just want to take a step back and kind of share a couple of stories that really brought this issue home. So my first 2 DWI trials in Superior Court, my first 2 jury trials were effectively .09 cases where I was arguing that the .02 allowance between 2 blows on the ECR2 breath test ticket, intox ticket, that the difference allowed of .02 basically meant that there is a range of error that is allowed for admissibility purposes and therefore calls into question the accuracy of a intox reading where it's within .02 of .07, long and the short of it. And so I can remember on my first case, and I really had dug into this. I had the intox manual. I really had spent some time getting cross-examination questions together on this issue. But I clearly lost on this issue in the county that I was practicing in district court. I talked to a couple of lawyers that were like, you may have a chance in front of a jury. This is not going to win in front of a judge in our jurisdiction. But I really hammered it in district court. Court didn't agree with me. Went to Superior Court, and I can remember standing outside the hallway during calendar call, and my case was going to be first up. And I remember one of the more senior attorneys, a guy that I really respect, coming up and asking me, what do you have going on for trial? And I was like, I've got a DWI. It's a .09 case. My client did great on field sobriety tests. So that's what we're teeing up. And he looked at me and he said, well, what's your issue? And I was like, the .09 is my issue. That's my issue. And he was clearly kind of like confused. He was like, that doesn't seem like an issue to me. It was the vibe that I got from him. And again, maybe I could have been misreading, but it definitely, first of all, kind of caused a little bit of a confidence struggle in my head. And then, afterwards I was like, you know what? I'm going in full send on this thing. So on my first jury case after a 2-day trial, the jury hung. It was basically, .09, not clear that my client is impaired, and you can't put all of the weight using Neyron Simmons. You can't put all of the weight into this intox ticket. This is not the end all be all. There is, presumption and beyond a reasonable doubt are not the same thing. Presumption of this being a .09 and it being a .09 beyond a reasonable doubt is not the same thing. And so, again, jury hung on that issue. Next week, same issue, different client. So basically, they tabled that case. The officer wasn't going to be available again the next week. So we did the same issue on a different case, and my client was found not guilty. And I talked with a couple of lawyers that were like, maybe you win this in front of a jury. I talked with a couple of other lawyers that were kind of like, had that same reaction of like, I don't know, this seems like not a good issue to try. And so I think that was really one of the moments where it was like, just because other people don't think that a novel issue is a good issue doesn't make it a bad thing to try. Some people don't like new. Some people don't like testing. Some people like predictability, whatever it might be. Some people don't like change. Again, whatever your preferences are coming in, you just have to recognize that in order to get not guilties on tough cases, you are going to have to push the envelope wherever it can be pushed. I remember one time I was down talking with a DA in Henderson County. And the DA in Henderson County was like, you know what, Jake, I like the way that you argue these cases. You're not like Bill Powers, who comes in and does all of this smoke and mirrors. And this is not going to be offensive to Bill Powers. In fact, this is about to be a pat on the back to him. So don't get all caught up if you're like, oh my gosh, we're offending Bill Powers here. Like, this is actually about to come back and really applaud Bill for the way that he pushes issues. But he said, I'm glad you don't push, these silly issues. You don't do the smoke and mirrors defense that Bill Powers does. And smoke and mirrors, the definition of that is the obscuring or embellishing of truth of a situation with misleading or irrelevant information. So obviously, if your defense is called a smoke and mirrors defense, then basically you're being characterized badly, so to speak, from the DA's office or whoever it may be that is talking about you like this. And so, again, I never met Bill at this point. I was kind of like, well, yeah, that's weird. Thanks for the compliment. I heard a similar phrase about Bill in Buncombe County a couple of months later. And I was like, man, what is this guy doing that is like so magician-like in the courtroom that is causing DAs to kind of like think, oh man, he's just like pulling stuff that doesn't work in the courtroom and trying to trick and misplay. I was like, what's going on? So I finally got a chance to observe Bill try a case in Buncombe County. He came in. We had a great conversation before the trial, and I was like, man, I've got to see Bill Powers try a case. He was legend among the defense bar, But I also had this perception of like, what does smoke and mirrors look like? And Bill went through the case and he challenged everything. He challenged reasonable suspicion, probable cause. He took the case to trial. He did an Aaron Simmons defense, and I was literally in awe. It was a clinic on DWI law, a clinic. Like you could have gone into this trial and just been taking vigorous notes. I was in awe about his mastery of the case law. And again, maybe a DA is hearing this same case and thinking, smoke and mirrors again. And I was thinking, here is a guy that knows DWI law backwards and forwards and is absolutely going to war for his client. And the issues that he is presenting seem to be very clear and worthy of trial. This is not something that is embellishment or obscuring. This is somebody that really understands the law. And it really changed my perception of the idea that, this issue doesn't work in my county, or, that's an issue that is not going to win on a DWI case. And I hear that so many times. And it's one of those things where, again, I can be a realist in some sense, but it really pains me to hear somebody say, the law doesn't work here. And that may be accurate, but it doesn't mean you don't push the law simply because you're expecting a different outcome. I have shared numerous times on the podcast how it has been so bizarre to win cases where I have looked my client dead in the face and said, we do not have an issue to win here. We don't have an issue to win. And won. My client was found not guilty. And and they're going like, I told you so. Like I knew, it's been almost frustrating at times because it's like, how in the heck did this go my client's way? I mean, I've done enough of these cases. I know the lay of the land. I know the law. I know what works with this judge. What the heck just happened? And obviously I'm happy. I'm happy it went my client's way, but it also is like, what is wrong with my preconceived notions about how this was going to go? So we're going to stretch the limits today, but I also think in a very clear and thought out path of how do you give yourself the best chance to win on a novel issue. If you want to present cutting edge DWI defense, you got to push the envelope. You got to try novel issues. You've got to add nuances depending on the facts and the law of your particular client's situation that give you the best chance of winning. So 5 ways to win a DWI in front of a district court judge on a novel issue. Number 1, don't let the novel issue come out for the first time in trial. Talk to your judges outside of the courtroom about DWI issues. Now, this looks different in every county. Some judges will come in and out of the lawyers' chambers where, you might find defense lawyers and prosecutors sitting around, bantering back and forth about cases and issues that they have coming up. Maybe this is only through like a one-on-one exchange. Maybe you have a case on a couple of weeks before. That judge is on the bench in the courtroom. You approach to the judge and say, hey, I've been thinking about this issue. Tell me what you think about this particular argument. Tell me what you think about this idea. This is critical because you have an opportunity when you approach a judge, not in the courtroom on the case that you're arguing, for a long form dialogue. You have the opportunity to have a conversation as opposed to what happens in the courtroom, which is an argument. You get to make a closing argument on the law in your case, but you get to have a conversation, a dialogue when you do it outside of the courtroom. You get to have a back and forth. Some judges will ask questions during your closing argument, but it's not really a meaningful conversation. You don't have the ability to say, let me look that up in the statute for you. Here's what I'm referencing. They don't have this kind of very informal back and forth. There's no pressure on them in this informal setting to make a call. So they don't have to give you a real-time answer. They don't have to make a decision on the spot. They can mull on it. They can think about it. You want that time for them to be able to think over the issue, do independent research, come back with questions. If you want a judge to buy into a novel issue, then don't present it as a novel issue, because when you present it in the courtroom, they've already heard it before, even though it was from you and recently. Talk to judges. Judges like learning about the law. Most judges became judges because they're interested in the law. If you're not interested in the law and you're sitting in a black robe, you're kind of in the wrong, area of practice, right? I would say you're in the wrong profession, but I guess we're all in the wrong profession if we're not interested in the law. But as a judge, particularly so, right? This is your whole job, is to be making decisions about the law. There's an interest there. There's a desire for learning, generally speaking, among judges. I think judges that I've interacted with, generally speaking, are curious about the law. They want to get it right. They want to know the nuances. They want to know the intricacies. They're fascinated by it. And that's cool, because I'm fascinated by it as well. So it's just important to have that conversation before you're actually in the courtroom arguing it in real time. So number one way to win your judge over on a novel issue is talk to them outside the courtroom before your case. You don't even have to present it as, here's the facts of my situation. Just, here's the statute. Here's what it says. What do you think? Now, they may look at you later on and be like, Mr. Minnick, I saw what you did there. You presented this down, a couple weeks back. But again, if you're not talking about the facts of a specific client's case, it's not unethical, because it's not something that you're trying to kind of talk to them outside of the DA's presence. You're allowed to ask questions about the law. So obviously you can't go talk to them about a specific case ahead of time. I'm talking about specifically just the law as it relates to a particular issue. Number two, you want to know the science of your case better than anyone else in the courtroom. The science. Now, some people say you want to know the, facts of your case better than anybody else in the courtroom. That's important. You want to know the science of the case. When it comes to how blood testing is done, how a blood draw is done, the science of what happens at the SBI lab, how a breath test machine works, PBT or Intox, standardized field sobriety tests, radar operation, accident reconstruction, drug recognition expert, retrograde extrapolation expert, serum conversion, all of these things. You want to know the science of how this works better than anybody else in the courtroom, better than the expert on the stand, whoever that may be, officer, lab technician, somebody from the hospital, drug recognition expert not involved in the case, accident reconstructionist, whoever it might be, whoever the expert is, you want to know the science better than that person. Let me just ask a reflection question. Why should we believe in SFSTs, in the science of SFSTs, as opposed to seeing them as a witch hunt? Why do we believe in standardized field sobriety tests versus just seeing them as a witch hunt? If you looked at this from an outsider's perspective, you had no idea what somebody was doing when they're doing the HGN test or walk and turn. If you were just a person that had zero experience about how a DWI investigation is done and you came up to an officer doing HGN, you'd think they were doing some sort of vision test. You'd have no idea that they're checking to see if this person is impaired by alcohol or some other drug. You'd be like, maybe this person can't see on the road. This is like some sort of spot check in terms of doing the DMV vision test roadside by a police officer. I don't know what's going on. The reason that we put stock into the SFSTs, and whether you do or not, the reason that judges do, the reason that a jury can, is because these tests are supposed to be scientific. So you have to know, as the attorney involved, what are the limitations of this science being utilized in this particular situation, in your particular case. How do you show your scientific knowledge? You do it through cross-examination. You have got to know backwards and forwards when you're cross-examining a DRE, the DRE manual. When you're cross-examining an officer on SFST, you got to know backwards and forwards the SFST manual. You've got to know the intox operator manual. You've got to know how the rules and regulations as it applies to blood testing. You've got to know what the lab procedures are when it comes to a blood case, when it comes to a hospital case. All of these things, you have to know it better than the expert that you are cross-examining. Because the default position when something is presented as science is for the judge to buy into it. If you're going to present a novel argument as to why Your Honor should not put weight into this blood test from a scientific perspective, why Your Honor should not put weight into the SFSTs, why Your Honor should not put weight into the way that the radar operation was conducted, the time distance measurement that the officer did, the DRE evaluation that was done, is based on limitations of the science or improper implementation of the science. It wasn't done correctly. Either the science is limited and it doesn't get us to beyond a reasonable doubt, or it wasn't properly executed by the expert that is involved. So you show your knowledge to the district court judge through cross-examination. You also show it through informal conversation. You're talking to the judge again at the bench. I went out to the SBI lab last week, and I got to do a demonstration and see where these things were done. I got to talk to one of the lab technicians out there. I just went and did the this 7-day course on the science of blood testing, right? I just went and did this 24-hour class on NHTSA. I just went and went through, a CLE that talked about radar operation. I just went and did a 3-day equivalent of what is done at DRE school, right? All of these ways, if you're talking to the judge, here's something that I learned from that. Here is what I found interesting about this particular aspect of the evaluation. Again, you don't have to just say, I went to the school, bring up something obviously that's an interesting talking point, but you're communicating to the judge, I have an expert level of knowledge about this issue. And when I bring up a point about what went wrong, it's because of the training that I went through on this specific scientific topic. Judges put a lot of weight in science, and there is a ton of shitty science when it comes to DWI cases, and there's a ton of shitty implementation of scientific method in DWI cases, and the only way to challenge that is to know the science better than the expert that is testifying in the courtroom. And sometimes there's no expert testifying in the courtroom. You've got to know the science of the intox machine better than the kind of non-expert operator of the intox machine. You've got to push the scientific issues. And if you know the science better than everybody else in the courtroom, you're much more likely to get buy-in from the judge as to why They should not be buying in to the science presented to them by the state. So number 2, know the science of your case better than anyone in the courtroom. Number 3, if you want to win a judge over on your novel DWI issue in district court, be the legal expert. Be the legal expert. This is something that I've hammered time and time again, so it doesn't apply just for this reason. But good judges don't like to be wrong. They don't want to be wrong about a decision. They don't want to be wrong about a case. And good for them for that, right? They want to come to the right decision. So you can show them your argument is right through argumentation, through logic, through reason. But they must also trust that the argument is right. They must trust that the argument is right. The reason why a DA wants to characterize a defense lawyer as a smoke and mirrors attorney when they're bringing up a novel issue is to discredit, to cause distrust of that attorney's arguments when they walk into the courtroom. And it's honestly a great character attack. It's a great ploy by the state. Because for the state, they're basically able to kind of make the same argument over and over again. They get to make the same argument over and over again. They have a DWI manual, right? This is why no matter where you go, I've tried cases. I don't know how many counties across the state that I've tried a DWI in, but it is a lot. And the presentation of evidence from the state is boringly similar because they're presenting it from the same standpoint. They're presenting it with the same outline every single time because of their DWI manual. Now, is there a DWI manual in North Carolina for the defense? Yes. Teddy's Trial Notebook. I mean, it's great. You can look at the NC Defender Manual. You can look at all kinds of great resources for the defense. So, I mean, they're similar, but I think that there's a lot more novelty presented by the defense. And so it makes sense from the prosecutor standpoint to be like, no, this is cut and dry, black and white. This is the same thing that we see, Judge, each and every day that we come in the courtroom. This attorney is doing smoke and mirrors over here. They're obscuring and embellishing the truth. They're misleading. They're providing irrelevant information. That's an easy way to discredit a good legal issue that the judge hasn't heard before, is to just say, you know, this is cut and dry. This is all the same. We do it every day, right? So how you overcome that is by constantly building up the trust, constantly being on point when it comes to everything related to a DWI case, sentencing factors when it comes to preparation on DWI cases, when it comes to the way that you cross-examine, when it comes to answering questions for other lawyers in the courtroom. You want to be the legal expert because you are gaining the trust of the decision maker when you repeatedly show, I know this stuff cold. I know it cold, you know, and you don't have to say it. If you have to say it, you don't know it cold. If you have to say it, then you don't have the trust of the judge. It's evident because of the amount of time that you spent on these type of cases and situations and been in front of these judges practicing. So you can't fake this one, and you can't do it overnight either. It's repeatedly working on your craft, repeatedly getting better, repeatedly attending CLE related to DWI, repeatedly bouncing your cases off of other experienced lawyers in the courtroom when it comes to DWI, focusing for the long term, niching down in this area or whatever practice area you're trying to show the judge that you are the expert of. But in order to get that buy-in, long term, you have to show that you are a master of this particular area of law. So, number 3, be the legal expert. Number 4, if you want to win on novel issues in front of district court judges, you have to do it on a unified front. It's much more difficult to be the only lawyer in a particular jurisdiction presenting an issue for consideration. The more that judges see a defense argument coming from multiple attorneys, the less novel it is by definition. It's not a novel issue when it's being presented by a number of lawyers, particularly ones that have been doing it for a long time. You have to talk to other lawyers about these issues. You have to get on the same page at local CLEs. You have to bounce your case off of other attorneys in the courtroom and say, here's what I am pushing. What do you think about this? And keep doing it repeatedly. Show other people in the bar. There's always another defense lawyer. I mean, well, not always, but almost always in a trial, there's another defense lawyer in the gallery watching the case get tried. They're soaking up these arguments. They're putting them into play or asking a question about them or saying, hey, why do you think this didn't work? Talk to the other attorneys in your bar. If you want to win on good, cutting edge legal issues, you have to do it in a unified manner, on a united front. Number 5, don't give up after pressing an issue the first time. Don't give up after pressing the issue the first time. If you want to win in front of a district court judge on a novel issue, you take it in front of them, you take the shot, right? This is the Wayne Gretzky, you miss 100% of the shots you don't take. That's what we're talking about today. Take the shots. Doesn't matter if you miss. You got to take the shots sometime. Otherwise, you'll never win. You can skate all over the ice, and if you never shoot on goal, it doesn't matter if you have 100% possession. You're not going to win the game. You've got to score in order to win. You got to hit the goal. So you got to take shots. But remember this, don't give up after pressing an issue the first time and losing, having the judge not buy in. Don't think to yourself, this issue stinks. Don't think to yourself, this judge will never rule in my favor. Slightly different facts may change the outcome. And I have seen this with judges. I have seen the same issue with a slightly different fact pattern be ruled guilty versus not guilty in front of the same judge months apart. Motion to dismiss granted, not granted. Similar but different set of facts in front of the same judge. It's just the situation. And that's what they're supposed to do. Judges are supposed to be looking at the individual facts of a case presented before them. But if there is slightly different facts that may change the outcome of your case, you also, again, may need to present an argument in front of a judge multiple times before they get buy-in. My kids, and I am embarrassed to say this, but as a parent, there have been plenty of times where my kids ask me for something, I say no. They ask me again, I say no. They ask me again, and I'm like, whatever. Like, I don't even know what I'm saying no about this. Yes, let's do it. Sometimes it's because they've asked repeatedly and something has changed. Sometimes I'm just like burnt out. And again, embarrassed to say this on the air, bad parenting, very likely. But sometimes you got to win by nagging. Sometimes the squeaky wheel gets greased. You have to push the same issues in front of the same judge sometimes in order to get a different outcome. Also, I think we are embarrassed, and I've talked about this on the podcast in the past. I think we're embarrassed sometimes when a judge doesn't rule in our favor and we want to go outside and we want to, talk to our client and explain everything. And, there's a lot of moving pieces going on after your client, goes from having a trial to now we're being sentenced, and I'm trying to get you set up with probation. The judge is now like out of the courtroom by the time this is all done. I'm embarrassed about the situation. Maybe the judge thought I was an idiot for bringing this up. I think there's a lot of different reasons why maybe immediately talking to a judge about a case after it has been heard may not make the most sense. But whether you do it immediately afterwards, the next day, the next week, ask the judge why they didn't rule in your favor. Your Honor, that case that we had last week, tell me what you were thinking about that. What did you think about that issue? What if this particular fact pattern were in play, or what was the reason that you ruled the way that you did? I think judges like talking about how they are thinking about a case. Again, judges are interested in the law. They're interested in how the law applies in a particular circumstance. They also, I think, sometimes feel bad about a decision that they are making on a case and how it's going to impact your practice, how it's going to impact your client's life. I think they're taking all of that into account. So it doesn't hurt to ask what's going on, because maybe they just say, you're an idiot. That was a dumb argument. I don't buy into that. I've had judges effectively say that, not in so mean a phraseology, but basically like, I just don't, I'm not on board with that argument. And again, like, respect on that front. Like, okay, let's maybe this isn't a good issue to present in front of this particular judge again in the future, but it may be much more nuanced than that. Well, I just didn't think that the time that they were held on the roadside was quite long enough. I think it was a close call, but that officer has done 800 DWI investigations. And so that really calculated into my thought process. If it had been an officer that had only done 20 DWIs, maybe you got something there when you're challenging PC on this particular case. Whatever the issue may be, I think a judge might say, here's the reason why I'm kind of looking at it from this angle. And so if you have another case that comes up down the road, you can evaluate it and say, here's how, if we land in front of this judge, this is going to have to be presented, addressed, how we want to kind of like phrase things, how we want to cross-examine the officer on this issue. Get the feedback. Don't be embarrassed to talk to a judge. Get the feedback. It's critically important. So there you have it. If you are trying to present a novel issue on a DWI, if you're trying to bring cutting edge DWI defense for your client in front of a district court judge, there are 5 ways that you can go about making that happen and giving yourself the best chance of getting the dismissal or not guilty on your client's next case. Look forward to speaking with you next time. And for those of you that are ready to come to Drive Shack in Raleigh, looking forward to seeing you there as well.